Welcome to the deep dive. Let's jump right in today with something that probably hits home for a lot of renters.
Absolutely. Dealing with rental service companies.
Exactly. Those property management firms, subleasing businesses, the middlemen. You find a place through them, you sign their contract, pay them rent.
And then inevitably sometimes something goes wrong.
Right. And that's when you hit this classic, really frustrating scenario we're going to unpack from the source material.
The blame game.
You got it. The company employee makes a promise, maybe about the condition of the place, and then boom, it's not true.
Or something breaks that shouldn't have.
And when you complain, the company tries to wash its hands of it, points the finger straight at the employee,
Oh, that wasn't us. That was just, Bob acting on his own. That kind of thing.
making it sound like a personal issue, not a company one.
Mm.
So our mission in this deep dive is to, well, cut through that noise.
Using the sources, yeah.
We'll look at tenant rights in these specific situations and pull out a key legal point that shows why that blame shifting often just doesn't work.
Giving you the tools to push back effectively.
Okay, so let's start with the case study in the source material. It involves someone named Xiao Lin. Really sets the stage.
Right. Shaolin rents a studio apartment, but not directly from the owner.
Through one of these service companies.
Exactly. Described as a well-known rental service company. So the company is the landlord, essentially, in the contract.
Got it. The company is the entity Xiao Lin is dealing with. So what was the problem?
It was the air conditioner, a pretty crucial thing.
Definitely. What about it?
Well, the source says the company's associate, let's call him Ming, specifically promised Shaolin the AC was brand new. Perfect working order.
Okay, sounds like a reasonable promise. Something you'd rely on. What happened next?
Shaolin moves in, and the AC breaks down after just 1 week.
Only a week. Wow. So they called a technician.
Yep. And the technician finds out the truth. It wasn't new at all.
Seriously?
It was actually a secondhand unit. They'd just put a new casing on it to make it look new.
Oh, that's bad. That's really deceptive. Expecting something functional, promised new, and it's faulty and misrepresented.
Fails almost immediately.
So how did the company, through Ming, respond when Zhao Lin complained?
And here's the crux of it, the frustrating part. Ming apparently tries to frame it as his personal mistake.
His personal mistake.
He tells Xiaolin the company didn't know about the AC's real condition, says Xiaolin should just settle it directly with him, Ming, individually.
Wow, so shrink the company's problem down to just him. Like, deal with me, not the company you pay rent to.
Exactly that maneuver, which feels incredibly unfair, doesn't it?
Totally. Is Zhao Lin just stuck dealing with Ming, who might not even have the means to fix it properly?
And that's the question the source material tackles. Is Xiaolin helpless here? Is this fair?
And the answer is,
A clear no, thankfully for tenants.
okay, good. So there's a legal basis to fight this. What's the key law the source points to?
It's Article 31 of the Rental Housing Market Development and Management Act. This is the specific law that gives tenants protection in these kinds of situations.
Article 31. Okay, that's the number to remember. How does it help tenants like Xiao Lin?
It basically lays out two really important points about the company's responsibilities, makes it hard for them to just sidestep blame.
Right, let's break those down. What's the first point Article 31 makes?
The first one deals with failures that are clearly the company's own fault. The source explains it simply. If the company can't fulfill its side of the contract because of reasons attributable to the company itself.
Like their own mess up.
Right. And that failure causes you, the tenant, harm, then the company must pay compensation.
So if their own internal processes or management fail and it affects a tenant, they're liable. They can't just blame bad luck if it's their own operational failure.
Precisely. Think about Shaolin's case again. If the company, through the contract or its employee acting for them, promised a working AC and the company failed to deliver.
Then they didn't fulfill the contract.
Exactly. And that prevents the tenant from using the place normally. That failure is on the company. They should be responsible.
Makes sense. What other examples does the source give for this first point?
Things like the company dragging its feet on repairs they agreed to do, and that delay messes up your life.
Yeah, okay.
Or if the company tries to change the contract terms without getting hurting your rights.
Right.
Even things like messing up your rent or deposit handling because their own internal systems are sloppy, that's all on the company's operation.
Okay, clear enough. If the company itself drops the ball on its contractual duties, it pays. But what about that Ming situation, where it looks like the employee screwed up and the company wants to distance itself.
Ah, and that brings us to the second point in Article 31. And honestly, this might be the most powerful one against that blame the employee tactic.
This deals specifically with employee actions.
Yes. It states that if the rental housing service company's employee causes you harm,
A tenant, right.
causes the tenant harm, either intentionally or through negligence, while performing their job. This is key.
Okay, while doing their work for the company.
Then the company has to bear joint and several liability for compensation, along with the employee.
Joint and several liability. Okay, that sounds legally significant. What does that actually mean for the tenant, practically speaking?
It's the game changer. The source is really clear. This means the company cannot just say, oh, that was Bob's personal error, nothing to do with us.
Because he was working for them at the time.
Exactly, because the employee was acting in the course of their employment, showing the apartment, making promises about it, handling the lease. The company is legally tied to what they did.
So the company is responsible with the employee. They share the burden.
Precisely. Joint and several means you, the tenant, can pursue the full amount of compensation from either the employee or the company or both.
Wow.
The company can't just tell you, go talk to Ming. They are legally exposed because their employee, acting for them, caused the harm.
This completely dismantles their argument in Zhao Lin's case. If Ming promised that AC is part of his job, and he knew it was bad or didn't check properly.
The company is on the hook right alongside him. The source explicitly uses Zhao Lin's case to illustrate this second point.
Because Ming was acting as their employee when he made the promise or was negligent.
Correct. The company must share the compensation responsibility.
Are there other examples in the source where this joint liability kicks in?
Yeah, several useful ones. Like if an employee gives you wrong information about the rent or fees and you lose money because of it.
Okay.
Or if an employee accidentally damages your stuff during a viewing or while doing property management tasks.
Right, that could happen.
Or even, unfortunately, if an employee takes your rent or deposit money improperly.
In all those cases, because it happened while they were doing their job,
The company shares the liability.
that really does change things. So knowing this, what should tenants actually do? What's the practical takeaway?
Well, the source gives some clear advice. First, just know this. The company cannot easily dodge responsibility. Article 31 is there.
So step one is basically don't buy it when they try to blame the employee and walk away.
Exactly. Be confident in asserting your rights. If you've been harmed because the company failed, point 1, or an employee messed up while working, point 2, demand compensation from the company.
And you can actually mention Article 31.
You can point to the principles. You're not just complaining, you're referencing the legal basis. Zhao Lin can tell the company, look, under Article 31, it doesn't matter if you didn't know. Ming was your employee acting in his role.
Okay. But what if the company just digs in its heels, refuses to negotiate?
Then the source says seek help. It specifically names places like the local government's Land Administration Bureau or Department or Consumer Protection Units. These agencies can often mediate or tell you the next steps.
So you're not alone just arguing with the company. There are official channels.
Correct. The source sums it up nicely. Knowing and using these rights is crucial protection when dealing with these rental service companies. It gives you a pathway.
Okay, so bringing this all together for our deep dive today. The big takeaway is pretty empowering. If you rent through one of these service companies, Article 31 acts like a safety net. It makes the company responsible for its own mistakes and makes them share responsibility joint and several liability for harm caused by their employees doing their jobs.
They can't just use that rogue employee excuse to leave you hanging.
Knowing the company is legally tied to its employees' actions and their work capacity is huge. It holds the actual entity you sign the contract with accountable.
It really does shift the balance.
Absolutely. Now, we focused on Article 31, protecting you after a problem pops up. But here's a final thought to chew on.
Okay.
If this law offers protection after the fact, what questions should you maybe ask before you even sign a lease with one of these companies, beyond just checking out the apartment itself?
Like how do you vet the company's reliability up front?
Exactly. Knowing this legal backdrop, what makes a company seen more trustworthy or less likely to cause these problems in the first place? What should you look for?
That's a great question for tenants to consider. Being proactive.
We'd love to hear your thoughts on that, or any experiences you've had with rental companies. Drop them in the comments. And if this deep dive was useful, please subscribe for more like it.
And just a reminder, drawing from the source, this discussion is based on Article 31's principles. Every legal situation can have its own unique details.
So consulting a lawyer for personal advice is always a good idea.
Definitely recommended for specific circumstances.
Thanks for joining us for this deep dive.
My pleasure. Good discussion.